I don't know. So one of the things about my role is that I get to do all the research, right? And the lawyers are doing case after case after case. So sometimes I know things that they know kind of intellectually, but I've got the research, and they don't have the research. So there are a lot of things like this equity argument that I've got the research on it, and I haven't had the time to, I need to write up an argument properly. I need like 2.5 hours uninterrupted, and I never get it these days. So there are all sorts of things that we could be arguing that they don't have yet, because I haven't had time to do something with the research that I've done. So you guys sometimes benefit from that, right? In Worcester, you guys sometimes get something before it's been, massaged and perfected and
I'm just wondering,
all the I's dotted and all the T's crossed.
if Judge Serrano did that.
I don't know that she would have, because the only folks who would be making that argument would be folks like Tom Vaughter or Rocky Ludden, or the really top-notch lawyers on our side would be the ones who would be making that kind of argument. So local...
So a pro se person couldn't do it.
Yes, no, a pro se person could do it, but remember that part of our problem is that the judge isn't listening very well to pro se folks to begin with, right? And here you're going to be getting in their face about what is your job as a judge? Like, what's the fundamental thing you're supposed to be looking at? You're supposed to be looking at the law and then the equity issues. First, the law. And I can give you the decisions why. But I don't know. I mean, Janet's done a lot of arguing. Janet might be in a position that she could do that. It's not easy.
No.
That now you're reaching back to, I was talking about the cases that were decided in the mid-1800s. That's where you're going for the equity argument. You're going quite a long way back. There's a great decision called Denny v. Mattoon, where what the court says is, and that was a judicial foreclosure, not a foreclosure by sale, so it was done in the court. And what the court says is that was done wrong. It was done by a judge who didn't actually have the authority. And what the court says is, if a decision like that gets made and it's done by somebody who didn't have the authority to do it, then you couldn't legally have taken somebody's property away from them. So it doesn't matter who bought afterwards, because there was no equity, there was no fairness to build up over time, because they simply never got the property. Yes, the judge gave it to them, but they never had a right to it. So it's as if it never happened. And if it never happened, then whoever purchases it, doesn't matter how long they've owned it, it doesn't matter how much money they spent. There's no, and that's the thing is, for a purchaser, like in your case where there's a third-party purchaser, there is no equity to build up. They have nothing, they have no value in the land at all. It doesn't matter how much they paid, because, my stolen car example, if I steal your car and I sell it to her, it doesn't matter how much money she pays me, none of it's going into the car, because I stole it. It's still your car. So it's even more true with real property. The weakness in the car analogy is that that's a movable piece of property. It's not that strict set of rules.
So when the third
Jennifer.
party purchaser bought Janet's house,
They didn't.
Did that pay off Janet's mortgage?
No. No, they pocketed money they had no right to, because they didn't have Janet's mortgage, right? It's a trust. They never got her mortgage. Somebody out there, so this is what happened in Joe Boyer's case, right? The trust forecloses on him. 5 years later, they evict him, and 2 weeks later, he gets a bill from a different party saying, we are the ones who had your mortgage all along. So that transaction that happened in Joe's case between a third party and the trust eventually purchasing the property, that money doesn't go towards his mortgage because the trust didn't have the mortgage, right? Somebody else did. This is why the SJC has said there can be only one mortgagee and only one note holder at a foreclosure, because if there's more than one, then someone else has a right to come after you. You're not supposed to be able to create a debt that multiplies in its existence, right? So, Lori, are you with us?
Sort of. That and Jerry's due.
Yes, it is. It was due a while ago.
No, it's due now.
Oh, they're sending us something?
Yeah.
Finally. Okay. Well, and it matters, right? Because you can't be writing, when you're signing a note, it's like signing a check, right? You can't be signing a check for $250,000 and not know whether there's going to be more than one party coming after you for the $250,000, right? I mean, that's basic law, and it's why we're having a problem when the appeals court makes a different decision than the SJC, which has been really clear that there can't be more than one party that can go after you for a check at a time. So, Jennifer, what I wanted to do, the reason I wanted you here, is because I wanted to take you through the decisions by the top court that relate to the fact that they have to let you challenge the ownership of the property before they can evict you.
Okay.
Okay? So it's fundamental to the idea that nobody could argue over who has a right to live in the property, the possession of the property, if they haven't already established that they own the property.
Okay.
Right? And what the judge is trying to say is that that's only true in cases where it's the homeowner versus the bank that had the mortgage. They're trying to say that if it's the homeowner against a third party that purchased at the foreclosure, or a tenant versus the bank buying back, that in those two circumstances, they don't have to prove that they own the property, which of course is ridiculous. Because if you don't own the property, you can't evict people no matter what the situation is.
Right.
Okay?
Now,
So,
do we know what the deed says for Jennifer?
I don't know what the deed says. It doesn't matter. The law is the same, and we're here to teach her the law. Okay? Because the law is always the same. It doesn't matter who purchased, right? The issue is if the foreclosure wasn't legal, whether it's the bank or a third party that purchases, it didn't happen. Right? So it doesn't matter. The problem is the court's being confused about it mattering, right? So in her case, it's a third party that claims to own the property. She asks for all of the evidence to show that the foreclosure was legal, and the judge says, well, they don't have the evidence, so you can't ask for it, which is putting the cart before the horse. It doesn't matter whether they've got it or not. They have to prove it. If they don't have it, then they're going to have the responsibility. To prove it regardless.
I'm just saying, I'm just asking the question because Judge Horn said last week with another case, what matters is who's on at the registry of deeds listed as the owner.
And what's the correct answer to that? If I walk in tomorrow and put a foreclosure deed on, some schmuck's house who I like the looks of, do I own it?
No, but I'm saying, do we
So-
even know if that's in there?
I don't know, but it doesn't
okay.
matter. The issue is if it wasn't legally foreclosed, it doesn't matter who bought it. It doesn't matter who has their name on the foreclosure deed, right? Foreclosure deed's no good, it doesn't matter who's on it.
She's wrong. Judge Warren's wrong.
Yes, Judge Warren's wrong about most things, right? There's nothing new about that.
And Grace, can I just ask you, the foreclosure, anybody can get a copy of that, correct?
The deed, yes, it's at the registry.
Okay.
So think of the registry as a public library
Okay.
of all of the documents related to ownership of land.
Because that's what she had as a document, right? So anyone could get that.
Yes,
You can
Yeah.
get it.
you have it, I think.
Yeah.
I think they gave it to you in Discovery, but
Yeah.
you also can have it off of the web.